Good evening, everyone. Welcome to week 6. We're a bit of a reduced number this week because the assignment is due tonight. So we'll be doing things a little bit differently. I'll be sort of doing a lot more of the talking. So we probably won't go for the full hour this evening or today if you're watching this on YouTube, which most of you are. So I'll do most of the talking. There'll be time for questions and things like that if anything pops up. But for the most part, it'll just be me running through a few things to briefly note about the course in general, and then we'll jump into the tutorial questions for this week. And I suppose I should begin by saying that this week we're a bit of a smaller content. And the main thing we're focusing on is our first ground of review, which is no evidence. It's pretty straightforward. There's not a whole lot to it. And I've deliberately put it here in this week's 6 slot because, we're about to break for Christmas. You're exhausted from doing the assignments. It's just sort of, if you wanted a cruisy topic, this is the one. So that's why it's here. That's why we're talking about it now. But before we get into that, I'll just very briefly share my screen to let you guys know about the My Experience survey, which maybe you guys have had emails about. We'll see. But hopefully you can see, so this is just the Moodle page, and there's a little green tab on the side here that says My Experience. If you click on that, it gives you a little, score of 0 to 10. Hopefully you pick 10, and then opportunity to offer a few comments. And this is separate from the usual student satisfaction surveys that you guys fill out at the end of the term. This is a bit more of sort of real-time student satisfaction. Those responses are completely anonymous. Those responses come to me almost instantly. There's a few hoops to jump through for me to actually view them, but they come to me fairly instantly. And so it's a really great opportunity for you guys to offer feedback about the unit as we go along, rather than waiting until the end of term. By then, the term's already happened. It's sort of too late to address any concerns that you've got. So if you want to, offer some feedback, that's a really great resource that's been rolled out across the university. So far, I've had 2 bits of feedback come in. One was someone saying that they really enjoyed the course. So that was really lovely. And thank you to whoever that was. The other one was a comment expressing some concerns about there being no week 5 content. And that's perfectly fine. And I'll address that in a moment, because I think that you guys do have a right to reasons, not reasons for a decision in the administrative law sense, but, a right to understand why there was no week 5 content, whereas in previous terms there was. And I think that really highlights what's so great about this My Experience tool, is that you can find out a bit more about the course and offer some feedback as we go along. And so the reason why we didn't have any week 5 content was I wanted to give you guys a really good chunk of time to work on your assignments. And the other reason was because in previous terms where there's been content in that week 5 slot and sort of right throughout the term, the 2 topics that we talk about today in terms of a bit more of the theoretical and principled aspects of a judicial review and the no evidence ground of review were actually 2 separate weeks. And as you guys will know, or you'll get to when you get up to that content, you're not thinking about the assignments, they are really short in isolation. And so those were 2 sort of very short weeks. I decided to combine the 2 together in this week 6 slot and completely free up week 5 to give you guys more time to work on the assignments. So you don't worry, you're not missing out on any content. There's nothing, there's actually a bit extra this term compared to last term. So don't worry about that. But thank you also for whoever that was who submitted that feedback, because that's what that tool's about, right? Is to let me know in real time how you're finding the course, any questions or concerns that you had, and we can address them as we go along rather than having to wait until the end of the term. So that's my experience survey. If you've got, a boring Christmas dinner or something that you're tuning out of, feel free to jump in and fill that one out. Or, as the coming weeks go by, please do feel free to offer any feedback, good or bad, that you've got. So let's jump into today's content. I was going to leave a little bit of time for questions about the assignment, but Kerry's already said that she submitted. So I don't think, unless you've got any questions, Natalie.
No,
No?
I've already submitted as well. So.
Fantastic. Excellent. Yeah. Cool. Well, we can move on from that part then. It makes things easier. So question 1 for this week's tutorial is about standing, which we talked about in week 4, which now seems like a really, really long time ago. So I thought I'd do a very brief recap on standing because it is a really important issue. It's also, and I know that everyone's brains are very much wired to the assignment or watching this recording, recovering from the assignment. So make a note of this for your future self. Standing is the kind of thing that makes for a really good exam question because there's lots of little sort of nuances that you can unpack. So if when it comes to your exam prep, definitely put a big star over the standing stuff because it makes for a really good, element within a question to ask about. So standing is, very broadly speaking, the ability or the right for someone to bring an application for a judicial review of a decision. You have to have standing in order to come before the court. And the test laid out in ACF and the Commonwealth is that you have to have more than a mere intellectual or emotional concern. There actually has to be something of substance. There has to be something that that goes beyond just, I'd like to challenge this, but it doesn't affect me either way. So we often think about someone's rights or someone's interests being affected by the decision or suffering some detriment or loss. So some of the aspects that we talked about in this unit and in the lecture materials are commercial interests, which is pretty straightforward, right? Are you going to suffer a business loss, or are you running a business in this space? Do you seek to get? Do you stand to gain some kind of business advantage here? Indigenous people sometimes have standing by virtue of their indigeneity, although that's a tricky and contested area of law in some respects. And so we contrasted some of the cases like Cohen-Gordon, where just the mere fact of being a descendant of an Indigenous person didn't itself give someone standing. But we can contrast that to Onus and Alcoa, where the court held that, by virtue of a group of Indigenous people's deep spiritual and cultural connection to a land, an area of land, that was sufficient to bring standing. So a bit of a tricky one there. But something to unpack potentially. Similarly, environmental interests can go either way, especially when they're combined with commercial interests as well. But the thing to really keep in mind here is that there might be, there's sort of a narrow test and a broad test or approach that can be used. And if you're representing some kind of environmental group, obviously you're going to go for the broad approach, arguing that, groups or individuals who really operate in a particular environmental space have an interest that just goes above what the ordinary public have, versus the narrow approach, which really strictly applies that intellectual or emotional test. And lastly, spiritual interests might sometimes give someone standing. So a strongly held belief, we're thinking about, Ogle and Strickland, where 2 Catholic priests had standing to challenge the rating of a film because it went, they thought it was blasphemous and it went really strongly against their beliefs. So they're not all the categories for standing, but those are some of the really interesting ones that we're looking at in this unit. And so question 1 for today looks at the issue of standing. I'll very briefly run through it. If you're watching this at home, it probably helps to have the week 6 questions open with you. So the scenario is that the Great Barrier Reef Marine Park Authority is a joint Commonwealth and Queensland authority charged with managing the Great Barrier Reef. And Agrico Australia, which is a subsidiary of Bioco, has approached the authority to get some approval to remove this dune grass on the basis of research collected by Queensland Museum from local Aboriginal people who were able to maintain this grass. And so Agrico thinks, well, there might be something to this. If we can do a bit of research on it, we might be able to, work out what makes this dune grass grow so well, and then apply that to, producing crops that survive in arid and salty environments. So the authority wants to conduct an inquiry about whether that would be a good idea or not. And they've written to several key stakeholder groups, such as the Cape York Land Council, the North Queensland Conservation Council, and the Queensland Department of Environment, inviting them to make submissions. But before they can do that, Agrico lodged an application to halt the proceedings because they think that the person holding them, Professor Carlson, is a noted environmentalist and a patron for the North Queensland Conservation Council. And they're saying that she might be biased, and so they want someone different. And so we have to advise on whether the following parties would have standing to be joined to the application. So whether they would be able to go be joined to the proceedings to argue about whether the hearing should go ahead with Professor Carlson leading it. So we might skip forward to some of the easier ones and then circle back to some of the hard ones. So we'll firstly go down to the Westie Farmers, who's a competitor to Agrico. They object to Agrico's actions because it might result in the company monopolising an emerging market, and they wish to defend future competitiveness and profitability. Sounds to me very much like a commercial interest that might be at stake depending on the outcome of this proceeding. So you'd expect that they might have standing. You might run into some issues because this proceeding is actually just about whether Professor Carlson's biased or not. But for the most part, you would expect that they probably would have standing because they've got a commercial interest. They've got a commercial stake in the outcome of this process because they stand to lose a lot of money potentially. And so that would go beyond mere intellectual or emotional concerns. Similarly, if we scroll up one to the Barrier Reef Regional Tourist Association, again, they're sponsored by local councils in North Queensland and they represent the interests of the tourism industry. And so they're concerned about what this proceeding the impact will have on tourism, and it claims to be representing its members. Again, we would expect that would be a commercial interest. So there shouldn't be too many problems there, I wouldn't think. The Cooktown Covens, scrolling up again. The Cooktown Coven is a circle of belief group organised around the tenets of Wicca. A central principle of Wicca is balance and harmony in all things, and the group believe that the interference with the nature of harmony is life-denying. They claim that researching this dune grass will interrupt the balance of things and facilitate life denial and evil. It depends on how you characterize this one a little bit. Obviously, the key issue is whether this is a spiritual interest or not. And the key sort of takeaway for this one is when we look at a case like the Right to Life Association and the Department of Human Services, where you had this Right to Life Association who were claiming a spiritual opposition to a clinical women's health clinical services in relation to abortions and things like that. They opposed it on a spiritual level, and so they said that they should have standing on that basis. But the way the court looked at it was, well, this isn't a spiritual or a moral issue. This is a health issue in relation to whether these clinics should be open 24 hours or not. And so the issue was framed in a way that sort of boxed out the spiritual side of things. So you could, if this was, if you had an exam question that was in this sort of style of things, you'd unpack, on the one hand, if you frame this as an issue of research, maybe you're saying that the spiritual interests don't really come into it. On the other hand, if you frame it in the sense of, what are the environmental impacts on this? We're holding this whole hearing to find out what those impacts are going to be. We've got this group of people who have this deep spiritual belief that interfering with this dune grass is going to upset, the nature of harmony. And so that's their belief, and they should have standing in order to make their case and make their argument in relation to that. So you could sort of weigh both sides. It seems as though the argument that this should be framed in terms of what is the impact, what's the natural impact of this activity going to be, is a bit stronger. And so you'd expect probably the Cooktown Coven would have standing in this instance. But there's a bit more of a debate that you could see. And a really good exam answer would consider both sides of the argument, balance those, and then come to a conclusion. And, even if I think that allowing standing is probably the stronger argument there. Even if you disagreed with me, even if you thought that they probably wouldn't have standing, I wouldn't be too worried about you coming to a different conclusion on that one, as long as you'd really carefully thought through both sides of the argument and explained it and explained why you've come down on that other side. That's fine. The Coalition for for Economic Justice is a business-based community group resisting financial imperialism. They object to Agrico as a financial imperialist, proven environmental vandal, and immoral genetic engineer. This very much seems to be a group who only have emotional and intellectual concerns. It's not clear on the facts that this group stand to gain or lose anything by this decision about the hearing. They're interested and they don't like Agrico, but that's pretty much it. And so that's their interest is merely intellectual or emotional. So we wouldn't expect that they would have standing. Let's scroll up a bit and talk through some of the other ones. So starting at the top now with the Cape York Land Council, who is the primary Indigenous advocacy group in Cape York. And it claims to represent the descendants of the people who were recorded in the Queensland Museum research. So, and they're funded by Commonwealth and state governments and are a major player in the politics of Cape York. So there's sort of two prongs to look at for this one. So the first is, does the Cape York Land Council have standing based on indigeneity? And here we would sort of contrast. On the one hand, what it seems to be on the facts is that the Agrico's research, Queensland Museum's research, which Agrico is sort of picking up and running with, has looked at the way that the traditional owners sort of maintained these sand dunes and the grass and things like that. And Cape York Land Council is claiming to represent the descendants of those traditional owners. That on its own seems to sound a little bit like the facts in Cohen Gordon, where it was held that merely being the descendants of an Indigenous group isn't itself enough to give someone standing. However, if you could tie it to the Cape York Land Council as representing traditional owners who currently have an interest in the land and currently have a connection with this land that's being with this dune grass is, then you start to look like a scenario that's much more similar to Onus and Alcoa, where the court recognised that a current deep sort of spiritual and cultural connection to the land did give Indigenous people standing. So this would be another sort of scenario where you kind of balancing competing views and arguments and ways of characterizing the interests to come to a conclusion. And you probably on this one would think that the characterization that sounds like onus and Alcoa would be a bit stronger. It's all rendered a little bit moot because they are funded by Commonwealth and state governments, and they were actually asked to make a submission to the inquiry. And so they've clearly got a stake in the outcome because they've already been invited to sort of participate in the process. And so if we take the broad approach to sort of environmental interests from Australian Conservation Foundation and Minister for Resources, which is the 1990 case, the later one, that was the broad approach where they sort of looked at different factors that would sort of lead you to expect whether or not someone would have standing or not. And so they talk about, the history of the group, whether they received government funding, which gives the group legitimacy in this space, whether they've been asked to consult before, again, gives them legitimacy in this space. All those factors point to the Cape York Land Council having standing in this instance because they've already sort of been brought into the process. They've got a clear stake in the outcome because they should be part of it to begin with. Next, we've got the North Queensland Conservation Council. Again, these guys were asked to consult and make a submission. So following that same logic, you would expect that these guys would be as well. They are regularly consulted on environmental management issues. They're funded through a combination of things, but government grants included. So again, we've got all these factors that if we take a broad approach, would point us towards expecting that they would have standing in this instance. Greenpeace,
Jacob, just a question.
Yeah, of course.
On the other one, Cooktown Covens.
Yes, yeah.
Could you have used the authority there as onus as well?
No. I think I see where you're going. Yeah. Correct me if I'm wrong, but so onus and Alcoa established that Indigenous people have a sort of this deep cultural, and it's tricky, right? Because it's sort of and I'm doing a horrible disservice to Indigenous culture by failing to explain this properly, but it's Indigenous people's relationship with the land is sort of quite complex and hard for non-Indigenous people to understand and explain. But the sort of the roughest approximation is to understand it in terms of this sort of spiritual, emotional, cultural connection that runs really deep and is just completely infused with sort of Indigenous culture. And so onus and Alcoa said, okay, this is, Indigenous people have a connection to this land that goes far beyond what non-Indigenous people have, and that should be recognised in sort of the standing process. In Ogle and Strickland, which was the case with the Catholic priests, the court kind of picked up that idea and ran with it to say, well, a spiritual connection to an issue can be grounds for standing. And so it was sort of, you could use Ogle and Strickland because that's the authority for this sort of more religious, spiritual aspect of things is more than merely emotional and intellectual. I'd use Ogle and Strickland rather than onus and Alcoa to capture this idea that, this Cooktown Coven, this religious group, have some kind of spiritual connection to this issue. The way that it plays out is going to impact on their belief system. And so they should be allowed to make submissions and have a say in how this process goes ahead. So I'd go I would go Ogle and Strickland rather than Onus and Alcoa. Does that make sense?
Yeah, it does. It
Cool,
does. Yeah.
cool.
Yeah. And it was interesting how Ogle and Strickland also drew on the onus comparison as well. So yeah, and
absolutely.
I think that's probably why I thought, well, could you actually then use onus as part of that argument when you're putting balance around, both arguments?
Yeah, it's I would focus on Ogle and Strickland. I can sort of see where you're going with this in the sense that Wicca, uh, and I don't know too much about the Wiccan religion in general, but on the facts here, it's sort of talking about Wiccans having a connection to nature and connection to the land as well. I would just be super cautious of trying to sort of force that analogy too far onto the Indigenous stuff, because in Onus and Alcoa, that was recognized as being, a uniquely Indigenous experience and a uniquely Indigenous connection to the land. I can see where you're going with it, but I probably would, I'd just fall short just of because of the way that Onus and Alcoa treated things, as a really uniquely Indigenous thing. But the way that those ideas were picked up and run with in Ogle and Strickland, definitely that could apply in this situation with the Cooktown Coven.
No, all good. Thank you.
So we were talking about Greenpeace, and we can distinguish Greenpeace from the Northern Queensland Conservation Council because they are, for one, an international environmental movement. Greenpeace Australia is obviously focused on Australia, but they're not focused on just the Great Barrier Reef or just Northern Queensland like the other group was. So that they're broader in focus. They don't accept funding from the government, but they are regularly consulted with by the government. And so taking the broad approach to environmental standing, you could argue it in the sense that the federal government consults with them, and so that gives them legitimacy in this space. But a lot of the other factors that make the Northern Queensland Conservation Council probably strongly likely to have standing, and that the court really applied to ACF and Minister for Resources. You wouldn't find them with Greenpeace. They're not focused solely on this one issue. They're really broad. They don't take government funding, that sort of stuff. You could make the argument, but it would be far less likely to be successful. And so you could come down on this one and say that Greenpeace probably wouldn't have standing, even if the North Queensland Conservation Council would. We've talked about Coalition for Economic Justice. We've talked about the Cooktown Coven. We've talked about the tourists. We've talked about Westie Farmers. So we've just got Father Reverend Fred Stile left. So Reverend Stile is a member of the New South Wales Legislative Council. Heard that an American company was going to do things with jeans and grass on Queensland beaches. And so as a defender of the nation's morals, he suspects insidious influences. And so here we kind of have to break down, Reverend Fred, and sort of what capacity he has in his, what standing he has in his capacity as a priest versus his capacity as a member of parliament. And so as a priest, obviously we're bringing up some of these spiritual issues as well. And in particular, his concern that as a defender of the nation's morals, he's worried about what's going on with these weirdo Queenslanders and their grass. But that's a pretty long bow to draw. It's the fact that he doesn't really have the full story alone suggests that really he doesn't have too much of an interest in this. You could take the sort of the really broad reading of Ogle and Strickland to say that this is an issue to do with morals, and therefore he should be able to have his say. But really, you would expect that this would be much more narrowly focused. The case really doesn't have anything to do with, Catholic, or I suppose it could be Anglican, Christian doctrine. And so you wouldn't expect he would have standing in a spiritual sense. And as a member of parliament, again, this isn't affecting the New South Wales government. And so, again, you wouldn't expect that they would have standing on this issue. So probably Fred Style wouldn't have standing. So hopefully and what this question is designed to do is to really just sort of scattergun a bunch of different parties and bunch of different issues to sort of showcase a little bit of the different ways in which standing can become an issue, and the different ways in which you can address them. So I would definitely, as part of your build up and your exam prep, I would definitely have a go at this question yourselves, just to sort of unpack those issues. Because like I said, standing makes for a really great element in a question, because there's all these little nuances and things to discuss. So it's well worth the time to make sure you've got it straight in your minds. But we might move on then to no evidence. And so you will see this in the lecture videos and the unit overview and stuff, but we're really moving now into the sort of the key phase of judicial review, in the sense that we've done our access to information sort of step. We've gathered information, and you're all, you've all done your assignments now. You're all really good at that, hopefully. We've dealt with whether judicial review is available, in the sense that, do we have jurisdiction? Is this issue justiciable? And does this person have standing? And so now we've said, okay, we know what's going on. We know that we can bring judicial review here. What are we actually going? What's the problem with this decision that we're going to run with? And so the next few weeks after we come back from Christmas will be all about different problems with a decision, and the different areas that we can use as grounds of review. And today we start with the shortest and the simplest, which is no evidence. And very simply put, it does what it says on the tin. It's, there was no evidence to support this decision. It's an erroneous decision because there's just nothing to support it. That breaks down a little bit into sort of two limbs. The first is that there's an essential statutory requirement, so some kind of criteria, but there's no evidence to support that criteria or to support a decision based on that criteria. And then secondly, the reliance by a decision maker on a non-existent fact. So the decision maker thinks something has happened or thinks that something's going on, but it actually hasn't. Those two, the distinguishing between those two limbs is a little bit artificial, because they do really overlap a lot. But it's probably clearer and easier to think about them in sort of separate, as separate limbs. And we'll see here what we mean by that. So question 2, Fred Smith applied to become, to join the AFP. And the AFP Act requires that a person be of good moral character. Sometime after he applies, he gets a letter from the AFP asking him to provide more information about previous complaints that he had committed domestic violence and assault against various individuals. Smith provided evidence that all the complaints against him had been dismissed because of insufficiency of evidence. So he was surprised when he later received a letter telling him that he didn't meet the statutory requirement that an applicant must be of good moral character. What legal advice would you give him? So the first thing that you'll notice about that question is that it's not as detailed as some of the other ones, and that's by virtue of it being week 6 and nearly Christmas. And the key issue about it being a bit more brief is that there's a bit more ambiguity in terms of what the legislation would demand. So in an exam, you would get given, like with the written assessment, you'll get given a stack of relevant legislation, and so that will be a bit clearer. But we'll talk about, what those grey areas mean for an answer to this question. So our first step, as always, is to look at the reasons for decision and our access to information step. And so here, again, we don't have too much detail. In an exam, you would get more detail. But here, what is really important about getting those good reasons for decisions is to clearly, it's been said that he's not of strong moral character. That's the decision. What we need to know is whether that's based on these claims of domestic violence and assault, or was it something else, right? In their sort of background checks and things like that, did something else pop up that suggests he's not of good moral character? We would expect, if he was asked to sort of give a right of reply for the domestic violence and assault claims, you would expect that if something else came up, he would get the opportunity to reply to that too. But we don't know for sure, and that's what the sort of reasons for decision are there for. So right off the gate, we need to know, was it this domestic violence and assault, or was it something else? And if it's something else, then that might be a problem, because there might be evidence for that, and no evidence is kind of ruled out for us as a ground of review. But if we assume that it's just this because he wasn't asked to respond to anything else, the second thing that we need for the reasons for decision is whether there was evidence to support those claims. Now, on the facts, it seems like there wasn't, because the claims, the charges made against him were dismissed. The complaints made against him were dismissed because of insufficiency of evidence against him. The sort of trick there is that trick is not a good word, because that makes it sound like I put it in there to trick, and I don't. I never do that. The thing to think about there is, and this is why, seeing the legislation is important, the standard that the decision maker at the AFP is, needs to be satisfied by about whether someone is of a good moral character or not, might not be as high a bar as the burden for, a decision to prosecute based on, for claims of domestic violence and assault, right? So obviously, if we're talking down the criminal path, especially, right, beyond reasonable doubt, as opposed to balance of proof, balance of probability, sorry, that's obviously different. But then even in terms of like a tort for assault or something, the requirement for there being enough evidence to prove that, the evidential burden for a federal police officer to say, or the decision maker in the AFP Act to say, I don't think this person's of strong moral character, it might just be that there was, that the mere fact that there was a complaint is enough to raise doubts about whether someone's of strong moral character or not. And so what we need to know first is what the standard of within the Act is. Maybe we can assume that because the charges were dismissed, there is no evidence at all. But it's something that, in the absence of the Act, would be worth discussing. Is, just because the charges were dismissed because of insufficiency of evidence doesn't mean that the AFP decision maker didn't have enough evidence to decide that he was not of strong moral character. So a bit of a distinction there that's worth discussing. And this is why, I don't know, I keep harping on about this. This is why the reasons for decision is so important, because, in putting out, this is my decision, these are the facts on which it's based, this is the evidence on which it's based, you have a clear statement there. Either we've got evidence of it or we don't. And so that's why that's really important. Let's assume that there is no evidence. These charges of these complaints were dismissed because there was just nothing there to find, and that the AFP haven't found anything since. The next thing that we're going to do is to look at the availability of judicial review. So looking at jurisdiction, this is obviously Commonwealth, and so we're thinking federal court. Justiciability, is this an issue that the courts would be interested in looking at? This obviously deals with, what was his name? Fred's ability to become a police officer, his interest, he stands to gain an advantage there. And of course he has standing because his interest in this decision is more than merely intellectual and emotional. He's got, he stands to gain or lose a lot from this. So we can fairly easily satisfy ourselves that judicial review would be available. And so then we come to talking about the ground review of no evidence. And so looking at the two limbs, if we frame so looking at the first limb of no evidence to support an essential statutory requirement. And again, this is why we need the Act. If the Act is worded in such a way that the AFP has to establish that he's not of good moral character, then we can see that as an essential statutory requirement, right? There's a requirement that the decision maker show that this person's not of good moral character, and there's no evidence to suggest that he's not of good moral character, therefore he must be of good moral character, and that essential statutory requirement hasn't been met. So under the first limb, we could say that there's no evidence because this essential statutory requirement, this finding that this person's not of strong moral character, it hasn't been met. Therefore, there's no evidence. Therefore, we can get review. If the statute was worded in the other way, to say that you sort of you're not presumed to be of good moral character. You kind of have to offer evidence to support that you are of good moral character. Then that sort of shifts the emphasis away. It doesn't become an essential statutory requirement as such. However, the second limb, the reliance by the decision maker on a non-existent fact, might still apply. And so here what we're saying is that the decision maker has relied on the fact that that Fred, was domestically violent and assaulted people. And that fact is just simply not established. And so here what we'd be saying is the decision maker has relied on a fact of domestic violence and assault that is non-existent because, Fred never did that. And so again, same conclusion, just different pathway. We're saying that there's no evidence for the decision that he's not of good moral character, and therefore there was an error of law because he didn't, there was no evidence to suggest otherwise. Does that make sense? I have spent a lot of time rambling there. Really what I'm trying to do is show sort of the difference between the two limbs. All good? Fantastic. Okay, that's good. For those of you who are watching at home, please do, of course, feel free to shoot me an email, and we can go over it in a bit more detail as well. But sort of the take home from this question is, one, of course, to show how important reasons are, but to sort of demonstrate that the difference between the two limbs turns on, is this an essential statutory requirement? Is this some kind of criteria that has to be met or not met? And what's the evidence to support that? Or is this just a decision that was based on a fact that just sort of forms the the overall factual matrix. It's not actually an essential requirement. It's not part of the criteria, but there's no evidence of this particular fact that the decision makers relied on, and that has somehow tainted the decision. And so that's the distinction, is to sort of look for the criteria or this essential requirement within the Act, which is obviously very hard in this scenario because we don't have the Act. But the question's structured that way so that we've got something to talk about, and so that we can sort of tease out those two options. The last question is a bit more of an essay question, and so its main value was to sort of stimulate some discussion and debate and some critical thinking about this area of law. So I might not actually weigh in on it, just because that would sort of defeat the purpose of the whole thing. And so question 3 sort of talks about arguably a difference or an inconsistency between the court's approach to no evidence in ABT and Bond versus Curra-Minding. So ABT and Bond, where Chief Justice Mason said that the proof of the non-existence of a fact critical to the making of the decision. And in Curra Queensland Mining, Chief Justice Black said that a decision may be flawed whatever the relevant importance of the fact. And so there's this sort of potentially a discrepancy between the importance of a fact that's non-existent or that there's no evidence to support. Does that actually matter for no evidence of a ground of review? So I won't weigh in on that one. Instead, I'll sort of leave that to you guys as something to think about, and something to sort of, just encourage you guys to think a bit critically in this space. It's also the kind of thing that, potentially makes for a good, critical, nuanced answer in an exam or something like that, in terms of if there's some, if the fact that has no evidence to support it is, if there's some debate about whether it's critical to making the decision or not, maybe you've got some room to discuss whether these authorities compete or not, and if so, which one is preferable to follow based on the interests of your client and things like that. So I'm not going to weigh in on that one. I'll leave that one there for you guys to have a think about, and to encourage you to think about this issue in this space. So I think I'll probably leave it there. So depending on when you're listening to this recording, we're in week 6 now. We're about to hit Christmas, and then we've got sort of a week off over the Christmas break. And so we come back for week 7 on the 4th of January. And so I know that this has all been a very choppy semester, starting and stopping and breaks and on again. That's sort of the nature of the beast with this Christmas break and things like that. But once we do come back on the 4th of January, we're in for the long haul. There's no more breaks. It's just weeks 7 through 12, one after the other. So that's that. When we're back for good. But a quick little announcement, just to say that we are off next week, depending on when you're watching this recording. The week 6 the week 6 quiz is open. That opened this morning as well. So make sure that you guys remember to do that. I've left it open for an extra day. So it's normally our quizzes finish on, start on Monday, finish on Monday. I'm ending this one on Tuesday, the 29th, just to give an extra day over the Christmas break. There's a lot of things going on. There's a lot of movement happening. So you guys have got an extra day to do that one, but please, of course, do remember to do it, and because it's easy to get sort of, for that one little mark, to get lost in all the craziness of the term. But that one mark might make a difference. So just reminding you guys that one's there as well. Cool. Well, we might finish up there. Thanks, Kerry and Natalie, for showing up. To all of you, I hope your assignments are going well. I hope by the time you're watching this recording, you've obviously submitted. And yeah, we'll be back on the 4th of January. So we'll see you all then. Bye. Yes, Merry Christmas and Happy New Year to you guys too. All righty, bye.